regarding the item number 20.
Item 20.
20, my lord. Meet, my lord, in the next week, my lord.
Okay, when?
Any day. 16.
Not next week. Reopening. Next thing, we are planning to complete all the pending works.
My lord.
8th of January.
Problem.
My lord, item 11, my lord, I filed the affidavit today. I'm allowed to bring to report, my lord.
Okay.
Please, Lordship, I beg to mention item number 4, Lordship.
Item number 4. Yes.
Sir, may we kindly adjourn for the day, Lordship.
Why?
Angus Council mother has expired, Lordship.
Who? Whose mother?
Mr. D.A. Kayum.
Ajay. After vacation.
Obliged, Lordship.
Yes, Mr. Dotto.
6, my lord. Yeah, my lord.
Hmm.
It's an old matter, my lord. Can I have the copy of the, my lord, impugned judgment? Actually, the file was missing, my lord. I applied for the certified copy. I got the same, but the judgment was not there, my lord. Can
Okay, Bothakur, are you having a copy?
Actually, I myself have gone through the court record, my lord.
Okay. You want a Xerox copy? We'll get it.
Xerox copy of
We'll get
the
it done.
judgment, impugned judgment
Impugned judgment. Which rated
of the sessions judge, my lord.
of the session judge? Huh? Just so it. Give a copy to both of them. Give a date.
Any date, my lord.
January.
My-
9th.
I'm obliged.
So what is this, Mr. Dotto?
It's a case, my lord, where, my lord, interim was granted, my lord.
Hmm.
Thereafter, my lord, imposing some condition.
Hmm.
But the bail order is not like that, my lord, that he shall appear before the investigating officer. And if he fails to do so, the bail order stands vacated. The order is not like that. In the order, my lord, it says, my lord, there are certain conditions, my lord.
Hmm.
So he has to appear before the IO within a period of 10 days, my lord. So he failed to appear within the period of 10 days as he was suffering from chicken pox. Subsequently, the police arrested him and produced before the court, and the court also sent him to judicial custody.
Both has committed. I was thinking yesterday whether to dig it or let it go as it is. The doctor advised us.
My lord, so far, my lord, the Sushila Devi's case is concerned, my lord, it is very specific. That if any conditions is violated by the petitioner or the accused, my lord, the only option is that, my lord, the IO or the investigating agency should come to the court, my lord, the court who had passed that order for vacating or,
But how we deal with the magistrate?
in fact, my lord, it was in the Supreme Court, my lord, in, my lord, Tusarwani Rajnikant Shah's case, my lord. Contempt proceeding was initiated, my lord. And the magistrate, my lord, got, my lord, unconditional apology, my lord.
Same thing in this case. Same thing.
I may be wrong, but I would just like to point out one thing what I have found in the order just now I have gone through. Well, the interim order passed on 22/4.
No,
Then there-
everything fine. Let us assume for a timing that he has not appeared. There was a direction.
Yes, then my lord, here,
Then what is the procedure to be followed? That is the issue.
yes,
We are not saying for a time being that he has not violated. Assuming for a moment that he has violated. What is the principle laid down and what is the procedure laid down by the Supreme Court?
my lord, I am just right, my lord, I may be wrong, my lord. I am just pointing out that here one order of the my lord, trial court on 23/5/2004. And in that order, petitioner Shri Prafullo Bora, oh sorry, my lord, he is Pulin Saikia.
He's pulling check here.
Pulin Sai-
That is the difficulty.
Because in that case, my lord, in the trial court, he has filed the, my lord, copy of the Honorable High Court order on 23/5, Prafullo Bora.
My lord, this 438, my lord.
See, this is one thing. One thing is that we generally should not let these kind of things go it like this way, because we are also having some responsibility. And the message should go to all that this is not the way you can handle a citizen, more particularly despite this order, hard at some length. Next year, Mr. Dutta.
Yeah, not one, maybe like Bhabiana. My friend was suggesting, my lord, so why can't a direction from the registry should be made all police stations?
That is what I was thinking, not only to the magistrate, not only to the officers, we may involve the Director General of Police,
Yes, yes.
saying that this is the law, so you issue a guideline and register to the magistrate also. And for the time being, as taking note of that, may be taking it to be that not willful, we may pardon them for this. Okay.
My lord, in that order, my lord, I have found that order of this Honorable High Court dated 22/4, my lord, 24 was placed before the Honorable Court by his brother Prafulla Bora on 23/5. Before that, my lord,
No, these are filed. Then what 2023/5, what he has granted bail?
an earlier order, that is order dated interim order 22/4/24, was placed before the Honorable Court only on that day, my lord.
23, that we understand.
Yes.
But problem is that when he was arrested and when he was bail granted.
He was arrested on, my lord, 18/5.
An order is dated, interim order is dated
22/4, my lord.
18/5, 22/4, 18/5 he was arrested. A specific stand has been taken that he has been granted.
Whether that order actually, my lord, placed before the IO, my lord, that is because in that order. it
No,
is-
this bail order is something different. Thereafter, he filed a bail application.
Regular bail.
And regular bail, and we have granted the bail on the day one. This is something different.
Sorry, my lord.
But
This-
yes, my lord, there's the
So
mechanism.
he was already arrested and he approached this court. And his specific statement that I have shown it to everybody. And then he came to this court, and this is the order 22/3. That is the order where he was released on bail by virtue of this court's order passed in BA, not in AB.
Well, one more thing, my lord, which I going through, I was thinking, my lord. If a lordship passes an order in the evening around 3:30, 4 o'clock, the next day happens to be a Saturday, Sunday, or 3-4 days holiday, my lord. It is not possible to obtain the certified copy also. So when the petitioner approaches the police, my lord, he says that I have obtained a bail. So at best, my lord, the advocate, the counsel who is appearing on behalf of the accused, he may write a letter on his pad, my lord. That is one aspect, my
Hmm.
lord. The second thing, my lord, there's some responsibility on the office of the public prosecution also, my lord.
Yes, that is there.
That is, but that
The
has to-
way, that's why why I have kept this matter after granting bail.
Yes.
Because of this, that's why I have kept it part, 2-3 issues. See, in the meantime, maybe by next year, if systems are updated, moment we sign a bail order, maybe interim, maybe final. If it is an interim order, it will straight away directly from us be transmitted to the concerned police station. Online.
Yes.
We are having a grid amongst the jail, police department and the all police department, high court.
Right.
There will be a database. They will also share their things. Suppose we want an FIR. So we can also have that FIR immediately.
Yes.
So these things will happen maybe by middle of next year when any order passed in bail will straight away go to the police station.
Right.
In his email, in police station's email, they will have to declare everything. Now they cannot say that we are not aware.
Yes.
That will come, but till that comes, we
Right.
cannot say that is good things will happen. Therefore, so give a date. We are just
And in fact, I was going through a judgment, my lord. My lord, it says, my lord, what happened, my lord? The judge dictated the order.
Hmm.
The steno had taken the order. But somehow, my lord, the judge expired, my lord. What will be the order? Peculiar situation.
nowadays we can until and unless the order is signed, that is not there.
Yes, my lord.
Yes.
That has to be
That
also said.
is
my lord.
the- So therefore, we want to have. That's why we want your assistance.
My lord.
You also propose what kind of guidelines should be there.
Hello.
You give a proposal, have a consultation with PP, And they might have also, don't take it to be an adversarial
Yes, yes,
litigation.
Yes.
Don't take it to be an adversarial litigation. Over enthusiasm will not appreciate of these officers.
Now, my lord, the division bench, my lord, in one of my case, although it's a habeas corpus, my lord, but division bench, our judge, my lord, he should be released forthwith, judgment will follow. So, that kind of things also there, my lord.
There. In fact, we have also passed in some cases, because we have dictated, dictated the judgment, delivering a judgment and dictating there, it takes time. So what we do, what I did is, I immediately issued that appeal allowed, he be released forthwith. Registry to issue the release order, detailed reason order shall follow. Within 5 days, we'll upload that. Anyway, we'll give a date as per your convenience.
After vacation, my
And
lord,
you give a note, what should be according to you as per the amicus curiae, what should be the guideline and deal with this kind of situation, not only the police, but also the magistrates.
after vacation, my lord,
Yes, give them.
vacation, my lord, we can have a
Yes.
Eight-
18th of January, heard in part for further hearing.
21.
21,
Oh, sorry, I'm looking the last year.
okay. 21st of January.
My lord. I'm obliged, my lord.
But Thakur, you also think of
Yes.
it. Don't take it to be an adversarial
Yes,
litigation.
Yes. Actually, my lord, I am not aware about the my lord, earlier BA order.
No, that is why. See, it was an interim. He was arrested.
Yes.
Immediately he came before this court. This court granted bail him on day one. And that's why we kept the anticipatory bill also. Then this matter we kept for that.
Yes.
Yes.
So in this case, I am appearing for the husband, respondent lordship.
Mm.
At 498A, after trial, I was acquitted. Against that, they preferred revision petition.
Hmm.
Ultimately, it was discovered that appeal lies. Then regular counsel, they stopped appearing, then amicus curiae was appointed.
Hmm. B. Sharma, where is B? MSB. She generally remains.
Yes, lordship.
She might have some difficulty today. We'll take after vacation. Due to a personal difficulty of MSB Sharma, I'm learned MSS Kuri, matter stands adjourned and be listed on 10th of January. Railway Council. What was the punishment?
6 months.
Go on probation. That's all. Go on probation. We are not sending him to the jail. Dispose of. Probation. But you'll get the order after vacation.
No problem.
Cannot be possible to upload during this.
I'm obliged.
See, there is an
taken after some time, my lord. The AR में तो लेंगे.
What is this matter? Which one?
Item number 3, my lord. He appeared on behalf of some other person, my lord. On behalf of his brother.
Okay, after some.
For hearing for a second time under section 494.
494.
The second marriage.
Hmm?
Second marriage is proved or not? That is the only issue, my lord.
Yes. You are for?
Respondent. Matter may be taken after some time. Seniors in legal.
Who is your senior?
Yes, Sharma. For some time.
Yes.
Convicted under section 420, my lord, 34,
420.
6 months, my lord.
What did you do?
some incident took place, my lord. It is one kind of like a fairy tale, my lord. That some devil also appeared, my lord, was to and give them amount rupees 3 crores, my lord. That's taken from them. My lord, there is a 4-month delay in lodging the FIR, my lord. Even though as per the statement deposition, PWs, my lord, they identified the accused on the month of October, my lord. And also they failed to lodge this FIR. They is on 26/2/2006, my lord.
Just a minute. You are Sofikur,
Sir, my lord.
huh?
Sofikur and both
Asghar,
Abdul Kalam.
Abdul Kalam. Who was that saint?
Well, that is the question, my lord. Who is the saint? As per the deposition made by some PW1, my lord, saint is Abdul Kalam. But no identification made by the independent witness, my lord. There is some contradiction, my lord. Clear contradiction.
Now, Barbar was examined.
No, my lord. That is the main question, but never before come before that land trial court, my lord.
How many days you were behind?
Not more than
For you,
one-
I will not do so hard works. You have cheated people, admittedly.
But my lord,
Yeah,
Sofikul is the one of
What
victim,
about
my lord.
Rafiq? What about you?
Sofikul is the one of the victim, my lord. As per the deposition of the PW2, my lord, PW2 deposed that I separately paid my share of money to the saint, my lord.
Now, what is the other Abdul Kalam?
Abdul Kalam is saint, my lord. As per the deposition made by the
Abdul
PW
Kalam is saying, okay, for a time being, we believe Abdul Kalam is the saint. But you are the main person, the middleman of the saint. Forget about the saint. If saint is also acquitted for identification and all, everything has been deposed against you.
As per my lord, PW1, my lord, as the installment was paid, my lord, PW2 categorically deposed that, my lord. I also paid my share to them. And after they collecting those money, my lord, they paid to the saint, handed over this money
No,
to
no,
the saint.
who brought the saint?
That saint, immediately the saint brought by me, my lord.
You brought the saint. then money was paid to the saint. Then he bought the god from the sky, and and the sky he brought so much of money. Then you pay money that for to fulfill your dream. Money has been paid. What more is? Why should we go to all these factual aspects in 482? How many days you were behind bar? And thereafter, how many saints you have brought after this case?
No, my lord, there is first incident. Learned my lesson, my lord.
How many days you were behind?
Hanuman
20
coin.
days or 20 days might be, my lord.
What is
Especially
the,
I-
how many?
Even my lord, police failed to recover the Hanuman mark coin, my lord.
Why Hanuman man coin is required to be recovered?
If my lord,
Why recovered? When the victim's statement remain unshaken regarding the incident, you introducing them to the god and taking money. And what more is required? Why should we acquit you and waste our time? Tell us.
because I am also a victim, my lord, in this.
You are not a victim.
As per PW2, my lord, I am
You
also
have not lost any complaint against the saint.
even the present victim.
You don't have any grievance.
My lord,
To
present-
mislead them, to cheat them, you have also paid your share.
And my lord,
present victim also lost this affair after 4 months, my lord.
and at this time also, my lord, he may be involved in committing this time in some other place. my lord.
Ah.
Developed a story, my lord. Informant. There is a huge delay in losing the affair, my lord.
How this Abul Kalam was convicted? What is the findings? Says Abul Kalam is also a appellant here.
Yes, ma'am.
Abul Kalam also paid.
So both are partners in hand. Appeal also filed together. What is the punishment?
6 months, my lord.
Be there. Any connection with you as on date with the client? You are still having a connection with your
No,
client?
my lord.
No. That is but necessary. Because they were supposed to follow some rituals for a month.
Then also over counting, my lord. 4 month delay, my lord.
And ultimately, while after 1 month, they met again, my lord, again does.
Initially, they went to the house of the Sophipol, my lord, on 30/8/2005. Then took time for 1 week, my lord. That means it will, again, they went to the house of Sophipol on 4 next month, my lord.
Everything is dealt by appellate judgment, all your argument, including delay.
Yes, ma'am.
Page 9, paragraph 18.
My submission was not considered, my lord. There is delay, my lord.
Yes, that has been dealt with. See, all these interactions and transaction amounting to 1,50,000 part by part had taken place for about 6 months from 30 2005 to 25 to 2006.
Oh, my lord, that
As it appears from the evidence of PW1,
No, my
PW2,
lord, that is not-
PW3, the accused person has misled all these those 7 persons to believe miracle of minting money with Hanuman brand coin by saint, and cat was out of the bag when the saint did not return after Ganga Snan, and on the following morning he was found serving. So you filed the loss.
apparently not correct, my lord. My lord, if I read, my lord, PW statement of the deposition of PW, my lord, there is, they only identified as per he is the statement.
Dismissal in the month of January. Give a date, January. No case. Have instruction. 6 months or 1,50,000 costs to be given to the persons. Either of it.
Obliged, my
22nd.
lord. Obliged, my lord.
Have that instruction,
My lord.
that much. And if he is happy that no, I'll be better off to take state hospitality, then he will be inside. Yes.
Obliged, my lord, obliged. Here in this case, my lord, convicting the person in EC Act, my lord,
Huh?
for 3 months with fine of 2,000 rupees, my lord.
3 months. What did he do?
My lord, I have used a domestic cylinder, my lord.
You use domestic cylinder.
For a purpose of commercial purpose, my lord.
Commercial.
In the
Commercial
hotel, my lord.
purpose.
Yes, ma'am.
So what do you want? So what can we say that since she is a lady and it is domestic acquitted? Can we say? No, what do you want?
Provision of offender, my lord.
He is the manager of that restaurant. And that company.
1 cylinder only,
Yes, one cylinder, my lord.
not much. Disposal,
Deeply obliged.
probation.
Please, your lordship.
Hmm.
My senior is on
Yesterday's matter. my lord,
That
regarding
matter.
copyright act.
some other day.
Okay, we'll take it up next week. 18th or 19th, something like that. Okay.
Please, your lordship, the matter may be
11. Hearing concluded?
On last occasion,
Ah.
We filed an affidavit
Ah.
to which
Yeah.
objection was taken by my learned friend, Mr. Das Miller.
Ah.
In fact, in that affidavit, they themselves say that he was the chairman, my lord.
Reply to the file today.
In the reply, they themselves say at page 866, it is stated that the deponent was chairman of GMDA from 24/10/18 to 26/2/21. And during this period, deponent constituted a statutory committee in terms of section 12 of the GMDA Act. So he admits that he was the chairman and the committee was constituted by him. And we wanted to bring on record that. So while opposing that, my lord, they have come up with this statement. Yes, of course. Candid disclosure.
Hearing concluded, judgment reserved.
My only submission is, my lord, while considering our case, my lord, Lordships will kindly have due regard to page 581 to 587. But in fact, we have made a small note.
Yes, that is what I want.
We have not
Five-
dealt with the affidavit as a whole,
Not necessary.
but briefly we have indicated.
581 to
581 to 587 and 602 to 603.
And
602, 603, 623, 624.
852,
we'll try to complete during vacation.
852 to 852.
So far as our affidavit, my lord,
That
para
will-
5 will cover, my lord. They have, my lord, raised some allegation, we have countered it.
Okay.
We have denied it, in fact.
Okay.
And my
And
lord,
these are already there in the other
Okay,
affidavit.
okay,
that we
no
have-
issue. Para 5 of
Para 3 and 5. 3, my lord, regarding the admissibility of the
Right.
affidavit, we have raised a, my lord, objection. And para 5. We have
and
replied to
moreover, my
the.
lord,
Huh.
it was during the course of proceedings of this case only, your lordship indicated that there is no pleadings in this regard, but you want to bring it on record. In fact, that is how.
3 and 5,
And
the
most
affidavit
part-
that.
Kindly see, let us, because my lord, end of the day, it's a, whenever lordship decides a matter on 226, my lord, there's always an element of public law.
yes, we'll look into this.
So, my lord, that, so here is a case, my lord, blatant misuse of authority. And kindly see, my lord, how the earlier permission was just not double, triple, my lord. These are the aspects, my lord. End of the day, my lord, the law has to be set at.
Yes, that is the object. Yes, your notice, dear,
My note is already there, my lord.
in the record.
Yes.
Please verify. I have got this Mr. Chaudhury's note.
Yes.
Huh?
25 one more thing. My lord, one
In fact-
judgment.
Yeah, my lord.
Kolo.
In fact, my lord, if your lordship recollects, my lord, our argument mostly was on the threshold.
On
That if
threshold.
it's contractual, it should go to
Yes,
arbitration,
yes.
otherwise.
Your is that only, and already arbitration obtained.
Going on regarding.
Going
the stay.
regarding same.
This
And
one judgment-
Basically, we are interested with the argument of GMC and GMD.
Yes.
That's all.
Yes. Well, this is a judgment regarding that bias part, my lord.
We are not
Just-
basic to the, basically, we are not deciding the factum of the contract.
Yes.
He is saying there is a violation. The GMC is saying there is no violation.
Yes.
These are the news. We'll see
That's all.
whether violations are there or not. That's
Within
all.
the statute. my lord.
But
Yes.
for that, there is already an appellate authority.
Your thing is that for there is an appellate authority. But I'm telling you, we will maybe that thing that is a self-restraint and
True, that, of course. Otherwise, my lord.
that part, other part I do not know, but that appellate thing, I may have to answer it in against it. But basically, we'll see how this project develop, reach this position, and at what stages, how is there any violation? If
Yes.
there is violation, there will be a decision, and if there is no violation, there will be
We
another
upheld.
decision. Even if suppose we say that he is a chairman, just this is a not final things.
Tentative.
Not final, just think, this is a thought process. Suppose he is a chairman. Now he is biased to his son, assuming for a moment. Now suppose he is biased, but we do not find anything on violation.
Yes.
Then what will be our decision? If we think that there is that biasness has a reflection in the decision,
So
these
So
are things
that- that is how, my lord, dispassionate way of looking at it.
yes. That is where I will look in, and hopefully, depending upon the weathers, the judgment will be on reopening. Muslim, just verify everybody's notes are there. Huh? Gogoi, And you just verify it, everybody's notes are there, huh? Because vacations are there, I will not be able to call
Yes.
you for them.
But
Yes.
the affidavit I have already called for, it will be.
No, that will come,
And my
but
lord,
your
we have-
written note, everybody
So,
wanted.
suppose our part is concerned only para 5, my lord, in affidavit also, my lord, in the addition.
No, not about that. The main arguments by Advocate General, not the GMC.
Para will be submitted, my lord.
Huh? You prepare a note because that was understanding. If you don't, I'll not say, but I don't want to miss anybody's argument, bullet points. I'm not saying a long written argument. I have already dictated your arguments, but I want to verify whether I have missed it or not. You submit it. Yes, thank you.
10, 12, my lord, have nothing more to add. Only thing, my lord, he was behind the bars for around, my lord, 1 month.
So many criminal methods just gone out of my head. What was this case? Just remind me.
Here, my lord, the charge was framed under 376. The punishment was given under 354. For around 1.
What was the punishment at that point?
Punishment is 1 year or fine or 1 year along with fine
So minimum should be 1 year
or fine.
or fine. And you have been.
It can be converted to fine also, my lord. That is,
So see, let us see, just remind me what was.
has been lawsuit fine at page 12, my lord. The point which was he decided at page 13, bill number 10.
Oh, that doctor and that the doctor, the pharmacist and.
Only one point was framed, my lord, whether the accused Sujit Daur attempted to commit rape on the victim. The only point was decided in favor of the petitioner, as he thus her body.
Where is her statement, testimony? Let us see her testimony.
Victim, I have flag mark, lord.
Huh?
Victim statement,
Give that, LCR.
LCR is given.
You have flag mark.
Pink color. PW1.
Why she went to the pharmacy?
Cross it, that line as well as the search. The for 376 only was not established.
Why is she saying that more হুশ নোহোৱা হৈছিল?
Clearly.
We have still
What the medical report says?
thing, my lord.
Hmm?
The report, there is not in the judgment itself. 16, my lord.
Any 164 statement? No.
164 statement is, it is in the judgment, it is said about it, Lordship, but I have not looked into it. 313 statement is also
No,
there.
313 I have taken. What did say in the 164?
As per what I have seen in the through judgment, Lordship, she corroborates. In 164 statement. 354 is there, Lordship, so consent does not look into it. If the 376, the matter would be different.
Your argument is that 354 could not have been, but that is not that is not an issue. 376 and 354.
Charge was framed on the 376.
So that is permissible.
Yes.
That is, I will not even record that argument. That is absolutely permissible. Now only thing on merit. Merit, her story is that I went for an injection. Then I got senseless. I was put in a bed. Then he touched my breast and private part. And asks, in cross-examination, she has given an explanation. That since I was in a senseless position, he asked, I opened my panty. That is your cross-examination.
Yes. How could she recollect?
No,
the-
we do not know. There is nothing. Senseless means she might be in a hallucination. Kind of that situation she explained. There is no other witness inside the room.
But as per her story, my lord,
Hmm.
the other witnesses heard from her only.
Hmm.
This did that when the plea of giving the injection, he asked her to enter the room when injection was. That much they said.
That itself is a 350. Forget about opening
Yes,
her.
but my lord, she did not raise any
She
objection.
is, but this is not your case of consenting. What is your stand all throughout is, including 313, is something else.
As you may consider, the trial was under 376. No charge was framed under 354. Though it is
Not
permissible.
necessary. Problem
No,
is
it
this.
It is permissible, my lord. I admit that it is permissible. But my lord, as the charge was framed under 376, my lord, the entire case was, my lord, dealt with, my lord, in a particular direction. That charge was not, my lord, established. Yes, what I am submitting, my lord, he was under, my lord, police, my lord, judicial custody for around 1 month. 2008, my lord, he is fighting in this case, one after another. He has learned his lesson. So now, my lord, at this, he may not be allowed, permitted to go to jail, my
What
lord.
was the prescription of on that at that point of time?
1 year, my lord.
Maximum.
Maximum 2 years, my lord.
2 years.
1 2
Or
years.
with fine.
Or
with
with-
both.
Or with
fine.
fine or with
Or
both.
with
So it can be fine also.
It can be fine also, my lord.
So it can be 20 days also. Period undergone. We'll argue, we'll record that you have said that she has suffered only
Fine.
period under. We'll not go in details all
Fine,
this
fine.
argument.
That can be done.
We'll say that you have confined your argument to the sentence. He has suffered a lot. In fact, though it was a case of consenting, the trial was not conducted in that way. Be that as it may, you say that the period it may be converted to period undergone. Would dispose of period undergone.
Obliged, my lord.
Yes, Dubey.
Recollect not the talk of compromise as regard
Ha ha ha.
but we are in the stage of finaling the agreement. That would be worked out by
It
next
is
Wednesday.
submitted that the talk of compromise between the parties is in the final stage and they will require some more time to complete the process. The learned counsel for the both the parties. Yeah. Accordingly, matters can adjourn and be listed.
Next week, if can
Next week will be possible.
possible.
Possible. Okay, next week.
Wednesday or Thursday, Monday, that's fine.
First. 19. Yes, Mr. Doctor,
Please, your lordship. Before
that
lordship,
matter.
that matter, lordship. 420 and 138, lordship. He has already passed away, lordship.
Ah.
The matter will be awaited against him, lordship.
Okay. And what about others?
Others, my lord, it will proceed because only petitioner number 3 has died, so it will be abated only against him.
The learned counsel for the petitioner submits that the petitioner number 3 has in the meantime expired on
Lordship,
23
23,
2022. Accordingly, he also produced a death certificate issued by Register of Birth and Death, Katigora Mini Primary Health, Register of Birth and Death, Katigora Mini Primary Health Center, Kachar, Assam. Full stop. The learned counsel of the learned additional public prosecutor has also not objected to such, has not raised any disputes as regards such death certificate, in as much as the respondent number, Mr. Chakraborty, you are?
My lord, I am respondent number 1.
Respondent number 1 also affirms as regards date of petition number 3. In view of the opposite, the proceeding stands abet against petition number 3. What about now petition number?
1 and 2, lordship.
What was the case? Just remind me.
In this case, lordship, one complaint has been filed against that petitioner as accused, lordship, alleging that check was issued by accused number 1, and accused number 2 and 3 also requested on behalf of accused number 1 to issue the check, and accordingly check was issued, but in spite of repeated request, it was not paid. That of check was also issued, check was also dishonored. Accordingly, notice was issued for NIA, lordship, no payment has been made and complaint has been lodged under section 420, 34 against all the accused and 138 against accused number 1, lordship. Barnett trial court initially took cognizance only against accused number 1 who issued the check under section 138. Matter went on revision, lordship, by the complainant, and revisional court has remanded the matter back to consider the matter afresh with a direction that the case is found against all the accused. And accordingly, Barnett trial court again framed charge against all the accused person under section 420 and 138 against accused number 1 only. That's why I came before this honorable court.
But there is a settled law. This can be done.
No, lordship, there is I have some differences in this case, lordship.
Yes.
Lordship, on earlier occasion, lordship has hinged about that case of Andhra Pradesh, lordship. Yes, Kutumba Rao case, lordship. That Kutumba Rao's proposition is that they are both 420 as well as 138, they can be proceed. But this judgment never postulated that of trial may be proceed simultaneously or in a same trial. Because
Yes, it is same trial that can be proceeded. There is some
My
judgment.
lord, in this very judgment itself, I was referring to on the last date. This
I think there is some judgments from our High Court also, my Lord Justice Ansari.
and even in the provision in CRPC also, it is there under section 218. Section 218 CRPC also provides for trial of different offences charged under different provisions. Paragraph 11, my lord, concluding lines.
paragraph helps my argument, lordship.
No, no, in this case, this is not the case. This is something different.
My lord.
Here issue was something different. This is not the case.
My lord, if your lordship kindly just takes up section 220 CRPC for a while, this will clinch it.
No,
because-
there is a clear
yes,
judgment.
there
Why
is a-
should you? There
but
is a clear judgment, clear judgment.
If your lordship,
Section?
section 220 CRPC, it's very clear, my lord. May I just read subsection 1, my lord, of section 220? If in one series of acts so connected together as to form the same transaction, more offences than one are committed by the same person, he may be charged with and tried at one trial for every such offence. This clinches the issue. Same act, same series of act. He was issued check, my client was issued check with the intention to cheat.
Suppose assuming for a moment, it cannot be done in the same trial. It can be very well done concurrently, simultaneously.
Here, Lordship, my submission, section 422, 420 is a warrant procedure trial, Lordship, offence.
Hmm.
And it is a case instituted otherwise on a police report.
Police
It is
report.
not on the police report.
Hmm.
And for that, section 244 of the CRPC will have to be followed. The magistrate will have to take evidence of all the accused witnesses person present by the complainant, Lordship. And thereafter, to decide whether he can be convicted if not unrebutted, Lordship. That is the consideration ought to have
But
been
do you
taken, Lordship.
propose to say that
And-
subsequent stages, no evidence can be brought in a CR case?
Can be, but my position, 138, Lordship, it is a case proceeded under a special statute.
Oh, that we understand.
And in this case, Lordship, an offence has to be explained, not the charge, Lordship. My learned friends, by referring section 220,
That we are not giving so importance at this stage.
because 220 is not applicable because 220 uses charge. So one case has proceeded on an offense explanation, and one case proceeded on a search, framing of search, and degree of consideration is much higher than the other case, Lordship. That cannot be simultaneously proceeded, Lordship. Maybe, Lordship, I do agree, two distinct offense, one cannot escape the liability of that rigor of that punishment. There may be a separate proceeding, Lordship. Maybe simultaneously proceeding in the same court,
There are
but
certain
in the same trial,
judgments,
Lordship.
there are certain judgments which I'm not getting. See, you are in a revisional jurisdiction. Server is the. Okay, we'll take it up this matter next week.
Lordship.
You just go through both of these. Anything, there is a issue formulated because there are two views by Supreme Court. Out of the same transaction, suppose 420, 406 and 138, whether can be prosecuted. Issue. Now the issue was reference was this, whether on similar set of allegations of fact, the accused can be tried for an offense under NI Act, which is a special enactment, and also for offenses under IPC, unaffected by prior conviction or acquittal, and bar under section 301 CRPC would attract for such trial. In fact, here is a case of two trial. But this was referred to a larger bench in the year 2022. This is in case of VJ Vedas Singh, Vedasingh versus R.M. Govindan. Okay, it is criminal, SLP criminal number 2864 of 2019. This matter has been referred to larger bench, taking note that in G. Sagar Suri and Kola Veera Rao, B. Sagar Suri's citation is just a minute. These two judgments, there was a conflicting and it was referred. Basically, the issue there was that trial of offense under section 420, 406 and 138 arising out of same transaction.
But different trials,
But different simultaneous trial is permissible or it will be a double jeopardy. Our question is not that. Our question is in a same trial. But if there is something in those, anything we can throw like these judgments are, it's not that.
Kutumba also harps upon that aspect only.
That is-
bar under section 300.
That is a different
That's
issue
a different
altogether.
issue.
In those cases, conviction was 138, subsequently 424, 0006 was initiated. But that was simultaneous. Whereas joint in the same thing, it can be done. You may find some light on from those judgments.
Lordship, I would rise, Lordship, on the next subsequent is.
Hmm.
138, Lordship, there is a procedure of submitting affidavit on evidence, Lordship. But it is not permissible under 420 warrant.
Okay, you argue
This
all
is
those
I will
points.
say. In another judgment in Malabar and there is a judgment, but in our court on that point, no have touched in.
That's why, hard in part. List for further hearing on after Bihu. It's an important issue. Let us, because I have not found anything on this, exactly on this point. I think so far I recall there might be a judgment of my Lord Justice Ansari. Just think over it, will be around 9, 10, I think 10, 11. Yes, next case.
21-1.
Yes, Mr. Vishwas.
This revision. Against the complaint case filed by my learned friend. In connection NI Act.
NI Act.
My lord, his contention is that he gave me 2,50,000 as loan. And against that, I gave him 3 checks, putting 28/5/2015. Was it 1 lakh? That 2 is 50,000. And I have not, he deposited it on 29/5/15, but there is intimation insufficient fund. I also give a reply to it. After he filed a case, is within time. But I have challenged the proceedings, that's why I have come.
You have challenged the whole proceeding.
My contention is that, so he's a very reputed supplier of the Government of Assam. And we had a very good friendship. And, he asked me that he have to give a security to the government against the supply order. So he doesn't have some sufficient money. So he asked me to give some check so that I can show it as a bank guarantee. Because of our good sweet relation, I have given it. But unfortunately, in connection with the purported supply, he did not get the supply. But he did not return the check also because I have given a blank check, but I just put in my signature.
I have not pressed also, but subsequently he utilized these three checks, putting the same date, 28/5/15. All the amounts I have paid. Against that I have come before your lordship.
But can you decide all this in a revision?
My lord, now one judgment I have got, my lord. I think it will give us some light, my lord. It's a 2008 volume 4 SPC 554, my lord. Here it is that, my lord, I'm reading, my lord. Negotiation Instrument Act, degener of checks, presumption against the accused, rebuttable of mode of necessary consideration by court, stepping into the witness box by accused, held not imperative for said rebuttal.
We have
Question of-
already passed a judgment, I think 3-4 days back, dealing with this judgment. What is the mandate of this judgment?
Then there is another question is that as per the Income Tax Act 269, there is a bar. The more than any amount is transaction is to be done, more than 20,000.
All these are your defense.
20,000,
All these are your defense.
that is true. That is true.
And this defense is to be taken before a trial court.
Yeah, very true.
You show us that no case under 138 is made out, we'll quash it. That this is not done, the notice is not given, this be apparently admitted uncontroverted facts. These are controversies. Whether you have given him sex as a security or it is due or not, presumption will be against you. But if he'll have to discharge, then if you can discharge, he'll have to prove it beyond reasonable doubt. That's all. If you can through his cross-examination, you can establish that though there is no liability.
But in this judgment, some guidelines has been given
Yes,
regarding
absolutely.
accounts, etc.
Yes.
Accounts, etc.
Huh?
Accounts, etc. Whether it is documentation, there was no documentation, what is the effect? Whether accounts is made, whether amount has been changed, whether on that day he in his fund 2,50,000 was there. He said that I have given a cash amount.
Did you file reply to his notice?
Yes.
Huh?
Yes, I have annexed it.
Do you have the defense?
That is true.
We cannot take the, can we, either we'll have to say you are correct or we'll have to say he is correct.
Very true.
Can we say?
No.
If no, Mr. Answer.
I leave it to Lordship.
No, don't leave,
This is my
Mr.
conception.
বিশ্বাস, you always leave it to the court.
My court is my lord. Court is to
No, court cannot be lords. Court will have to pass a reasoned order on the basis of material available on record, on the basis of settled principle of law. We might be called lord, but we cannot be lord. As simple as that. And don't leave it to us. Enlighten us. You argue your case that this is the principle of law. You also know what is
This
the
principle is not followed by the court below in most of the
no. Whether this principle is followed or not, it is to be a matter of trial. See, here simple case is what is your case? Your case is that this is a check which has been given as security for some business, for his business. Not even for my
Not for
business.
mine.
My business, given to his business, but he misused it and presented it, and I don't have any liability with him.
No liability.
No liability. So,
And NI Act is, the burden is that there must be a liability.
yes, so must be liability, and presumption is that check is issue means there is a liability. That is the in the wisdom of the parliament, the act is structured in that way. Now, if we have to allow your petition, we will have to come to a conclusion that yes, this petitioner did never issued the check for any liability. And therefore, it cannot be said to be against any liability. This was a check for somebody's guarantee, not for. That is a matter of trial. But
One judgment of the Honorable Supreme Court on this very same issue.
heard Mr. S.C. Biswas, learned counsel for the petitioner. Also, this is item number
15, my lord.
15,
DC Chakraborty.
Chakraborty. Also, Mr. DC Chakraborty, learned counsel for the respondent. What is IA criminal?
I submitted because for stay order.
They was there.
Yes, ma'am.
Huh?
It's 1099.
Then what is the present status of the proceeding?
Pending.
Pending, ma'am.
Pending.
it is. Because of. Yes.
The present application is filed under section 482 of the Criminal Procedure Code 1973, read with 1973 for quashing of the complaint case registered as
Registered as my lord.
registered as NI case number 156/2015 under section 138 of the Negotiable Instrument Act, which is pending for trial before the learned additional chief judicial magistrate Kasar, Silchar. The complaint case was filed by respondent number 2 under section 138 of the Negotiable Instrument Act. The aforesaid proceeding is challenged by the petitioner primarily on the ground that the said proceeding is an abuse of the process of the case. According to the petitioner, the complainant and the accused petitioner are very close friends and were having cordial relation. The complainant, for some business requirements, complainant for some accused petitioner took an amount of rupees 2,50,000 as loan from the complainant on 15/2/2015 and returned the same on 28/5/2015 by way of 3 numbers of checks
Dated 28/5.
dated 28/5/2015 of Grameen Vikas Bank. Said checks were deposited, were returned back with
29/5.
on 29/5/2015
Sufficient fund.
for the reason of insufficiency of fund, and thereafter a notice was issued by the complainant on 17/6/2015. An accused petitioner replied to the said on 8/7/2015, denying the liability, but admitting the issuance of the check, issuance of blank check without filling up date, names, etc. upon the check. Subsequently, court below took cognizance under section 138 Negotiable NI Act and issued summon under its order dated 7/9/2015. Full stop. Thereafter, the accused petitioner appeared before the learned trial court, which was enlarged on bail. Full stop. The present application is filed with the contention that no loan was taken by the accused petitioner as alleged by the complainant, inasmuch as the complainant has failed to show the mode of payment of such loan either by cash or by check. Inasmuch as such amount of money cannot be paid in derogation of the procedure laid down by the banking authorities. It is the further case of the accused that the complainant wanted some blank check to submit a security checks against his purported supply order from different state agencies, and accordingly, with good faith and belief, and for the reason of having good friendship, the petitioner issued him, the accused petitioner issued the blank checks to the accused petitioner, and and however, the complainant used such check even after there being no liability from the side of the accused, and therefore this is an abuse of the process of this court. This court is of the opinion that the aforesaid grounds and defense raised by the accused petitioner can be a subject matter of the proceeding of CR case number so and so, so and so. Inasmuch as this court, in exercise of its revisional jurisdiction, cannot conclude either way, that is either cannot conclude those factual disputes, inasmuch as such factual disputes and factual defense are required to be proved as mandated under section 138 of the Negotiable Instrument Act. Therefore, this court is of the opinion that this is not a fit case for interference with for setting aside and quashing CR case number so and so, inasmuch as the learned magistrate, after perusal of the complaint and after perusal of the complaint and taking consideration of the statement recorded under section 202 of the CRPC, took cognizance of the offense under section 138 Negotiable Instrument Act. The fact further remains that no other ground is taken to quash such proceeding, such as that no case under Negotiable Instrument Act is made out, or that the procedure mandated under Negotiable Instrument Act is not followed. Then being the position, present petition stands dismissed. Dismissed. The learned trial court shall proceed with the CR, shall be at liberty to proceed with the CR case. In view of the order passed in criminal petition, IA criminal so stands closed. What is a serially matter? Yes. Yes, what is this?
Submitted the translated copy of the evidences along with a written lordship, it is in your record.
Where?
Translated copy of the
Who are you? How many petition?
There are 6 witnesses, my lord.
No. How many people are there? How many petitioners are there?
5, 1 and 6, my dear. 1 and 5 during pendency of the matter died, my lord, and 2, 3, 4 remain.
Who died?
1 and 5. Petitioner 1 died on, my lord, 26/3/2014. And petitioner number
26
3 March 2014.
49.
And petition number 5 died, my lord, exactly date I don't know, but year is 2016, my lord.
Now how many petitioners left?
2, 3, 4. Their brothers, my lord, sons of petition number 1.
Who was the injured witness
The PW5.
and PW5
only
injured?
PW5. His name is my lord Ekhlasuddin Borvia.
PW5, which page?
46.
46.
Yes, my lord.
What was the name of this, the 2, 3, and 4?
Yes, my lord. 2, my lord. 2 is the Zakir Hussain, my lord.
2, Zakir.
The 3 is the Alta. That is exact good name is my lord. I'm giving you.
Altaf, and
My lord.
4 is?
4 is Anar. That Farooq.
Who is 1 and 5?
1 is the my lord.
Sir,
Father of
Name.
name my lord Aftabuddin Borloskar.
And who is 5?
Faruquddin Loskar.
Now, who are the other witnesses?
Yes, my lord. One is the informant, the father of the victim, my lord. 1, 2, and 3. I mean, they are interested. They are not eyewitness, my lord. Only the victim, regarding.
There is no eyewitness.
Oh, yes.
No eyewitness.
So far as my lord, medical evidence.
Prosecution also has not projected any eyewitness.
No, my lord. Interested, sorry, no, the other witnesses is protected, my lord. And my lord, our intent contention, my lord, that the injury received, whatever said by the victim, my lord, it is corroborated with the PW4 and PW6, there is MO and IO, my lord.
Where is the PW4 and
Yes, my lord.
PW6?
PW4, lordship, you will find at page 44.
PW4 MO,
PW6 IO.
IO. Page?
Page, my lord, 44.
Page 44.
Page 44 is the PW4 and 52 is the PW.
Just then, PW4 is page 44 and PW6 is
Is page 52.
52. Yes. When the date of incident?
Date of incident 10/5/2005.
Okay, and
IO, my lord, page 52.
Ayo,
52, page 52, my lord, W6. Cross purpose.
yes.
PW3 maybe look into it actually. Page 40. He seems to be an eyewitness, lordship. It's a mayor, lordship, in the
Hmm.
middle. On my arrival at the place of
Just a
occurrence,
minute.
lordship. Page 40, lordship.
Yes,
Lordship, in the middle, occurrence in a run. On my arrival at the place of occurrence, lordship got it.
yes.
I saw accused Aftabuddin saw lordship
Hmm.
making direction to his son Zakir to catch Ikhlas as per Aftabuddin's direction. Accused Farooq and Zakir caught hold of him, that is the victim, and assaulted him on his entire body. Accused Farooq and Zakir beat Ikhlas, that is victim, lordship, beat up by means of lathi, lordship. Accused on the next page 41. Accused Anar and Alta dealt blow to the head of Ikhlas by means of rod and caused bleeding, injury to him. This is all, lordship.
Cross part, my lord, important.
No, no, we'll see. You see everything. Don't be excited.
Lordship.
We are taking a life and
Yes,
death
sir.
question of a person.
Yes.
Don't be so excited. Yes. What you want to say from the cross?
Cross, my lord, your lordship will find.
You ought to have cross-examined this. You have affirmed what is not required. See, we all went to the place. I went to the place of occurrence when the assault was being made. This is your cross-examination.
He cross-examine, he said different. That, my
Huh?
lord, cross at 7 line, my lord.
Huh.
He said, on my arrival at the place of occurrence, I saw the accused person fleeing therefrom.
Fleeing
Yes,
therefore,
yes.
there can be, it is not a material contradiction. Here is this place, saw beating, then
Okay.
fleeing.
Lordship.
Two things can happen.
He has said that,
This is not a material contradiction.
and cross, he said, they, on his arrival, they fled.
Any other eyewitness?
No, lordship, this one.
So basically, interested witness, contradiction, not corroborated by medical evidence.
Then I will, my lord.
IO.
But
Okay,
on
well,
the on head is there, lordship.
where is that, doctor?
Doctor, lordship 6.
Page 44.
Page 44, lordship. One lacerated injury is there, lordship. Parietal region of the skull.
And his conviction is under
23, 3 months, my lord.
3 months. We'll come back after 5 minutes. Yes, Pathak, that is your case, na? That he is inside.
Yes.
Anything, have you got anything? regarding S?
I went through your lordship's judgment. For judgment as well. But I think the lordship has held in the laid down in the Juvenile Justice Act has not at all been followed.
Then
At least in the previous case, the medical board was constituted. Here only on the basis of a medical practitioner who has gone through the report of another doctor who was not examined, the age was determined.
the case of acquittal. Perhaps. If case of acquittal will take up,
ছিলাম খেলার মধ্যে ওখানে পেরের মধ্যে ওখান ঘালের ঘটনা হয় আমি দৌড়াইয়া ঘটনাস্থলে যাই আমি গিয়ে ঘটনাস্থলে দেখি আসামি আফতাবউদ্দিন দ্যাট ইজ নাম্বার 1 মিনিট আফতাবউদ্দিন তাহার ছেলে জাকিরকে নির্দেশ দেন জখমি একলাসকে ধরার জন্য আসামি ফারুক এবং জাকির আফতাবউদ্দিনকে নির্দেশ মতে আসামিরা ধরেন এবং সমস্ত শরীরে আঘাত করেন আসামি ফারুক এবং জাকির একলাসউদ্দিনকে লাঠি দ্বারা মারপিট করে আসামি দ্বারা আলতা বড় আর একলাসে মাথায় আঘাত করেন এবং সাহায় রক্তাক্ত জখম করেন তারপর জখমীকে বহন করিয়া নিয়ে হসপিটালে যায় আর আমি তাহার পিতা সহিংস লোকে ওখানে সঙ্গে গিয়ে হাসপাতালে আমি এবং হাসপাতালে নির্দেশ থানার গিয়া যায় আর জখমীকে হাসপাতালে করিয়েছেন হয় আমি বলিতে পারিব না পুলিশ সরজমিতে আমাকে জিজ্ঞাসা করে নাও আই এম রিডিং দ্য ক্রস পার্ট মিলট বাদী বশিরউদ্দিন আমার আপন ভাই জখমী আমার ভতিজা ঘটনাস্থল হইতে ছেলেরা মাটি 200-250 মিটার দূরে ঘটনার পর হাল্লা চিৎকারে আমরা সবাই ঘটনাস্থলে যাই হাল্লা চিৎকারে 100-150 জন মানুষ জমাতো হয় মারপিট চলার সময় আমি ঘটনাস্থলে যাই আমি ঘটনাস্থলে পৌঁছার সময় দেখি আসামিরা পলাইতেছে আই এম অন দিস পয়েন্ট মিলট in this case, Milord, in the chief, he has said that, Milord, he narrated whole facts as the facts stated by the PW5, Milord. That he has seen that after Putin instructed his sons to cut him, and after one after another lathi or rod injured him. Like this man, he has stated things. But here, Milord, in the cross part, he has said that at that when he
see, just let us get clear. মারপিট চলার সময় আমি ঘটনাস্থলে যাই. So when মারপিট was going on, I reached the place.
that means
আমি ঘটনাস্থলে পৌঁছার সময় দেখি আসামিরা পালাইতেছে. They were running. They have not already fled.
Here, Milord,
When মারপিট was there, I reached the place, and when I reached the place, they fled away.
Same transaction, Lord.
Same transaction.
W3, Milord.
See, forget about this witness.
Milord.
Discard this witness.
Yes, Milord.
Discard this
Yes,
witness.
Milord.
Then also,
There are interesting
there is an attack by 3 person. He got injuries corroborated. Conviction is for 323, 325,
23, Lord.
323, rightly 323, and only 3 months.
While Milord, since Milord, the injury,
And we are in a revision. Both the court concurrently found it.
why Milord, Lordship, one decision Lordship has asked us to Milord that when this interfere on this point, Milord, and this point, Milord, I humbly submit, Milord, 323 is the case 1 year or up to 1,000 or fine of rupees 1,000 extend to 1,000, Milord. Since it's the case of in the 2005, Milord, now 2020.
Now, how many days you were inside jail?
That knowledge I
Please see, look into this. Come on. I'll share.
yeah. Paying for bail,
886.
886. Full bail on.
RFK 10,000. Two. 22 8
Bailable. No, it's bailable offense. It is
Bailable
there, but
offense.
police has granted
Police has
initially bail.
granted bail. In regard to PW3, I can want to only focus on one thing, Lordship. It in cross part, he specifically stated that it is not a fact that I neither saw the incident
No, he
nor
has denied it.
denied Lordship.
Just farm.
From
What was the fine imposed?
But of each
And what is the maximum fine prescribed?
1,000 million.
imprisonment for is 1 year and fine is for 1,000.
Extend
A period of imprisonment up to,
1 year, Lordship.
so it can be 0 also.
Zero.
What you say, Mr. PP?
Lordship, otherwise, it is there.
No, it is,
there, Lordship.
I do not think this is a case for interference in exercise of revisional power.
Lordship.
What is required is factually proved,
Lordship.
and therefore such concurrent finding of facts cannot be said to be perverse, and therefore we will not interfere. Now, what remains is arguing for lesser sentence,
Lordship.
taking note of he has suffered how many years of 19 years of trial, appeal, revision, and that there was some previous enmity, civil dispute between the parties. Fine is maximum.
Maximum
1,000
1,000 rupees.
He submits that fine may be enhanced. What do you say?
Maybe.
Hard.
My friend Ayaz Loskar name may be recorded. Yes, he initiated this hearing, my lord.
He's here,
His murder's operation is going on.
but he's in Guwahati.
His party.
Hold on, counsel for the petitioner. Learned promotion. The present application is filed under section 401/397 under section of the Code of Criminal Procedure 1973. Assailing the judgment and order dated 12/3/2008 passed by the learned Chief Judicial Magistrate Hailakandi in GR case number 377/2005, convicting the petitioners under section 323 IPC and sentencing them to undergo arrive for 3 months and to pay fine of rupees 250 each. The further challenge is impugned appellate judgment dated 27/5/2013 passed by the learned Session Judge Hailakandi in criminal appeal number 5 of 2008 preferred by the present petitioners, whereby the judgment and order dated 12/3/2008 passed by the learned Chief Judicial Magistrate was affirmed. During the pendency of this revision petition, the petitioner number 1 died on 26/3/2014, and the petitioner number 2 died in the
Five,
year,
five,
huh?
five.
Petition number 5 died
16.
in the year 2016. Such facts has not been disputed by the PP. Learned Religion Public Prosecutor. Accordingly, the proceeding has been proceeding stands abated against the accused number 1 and accused number petitioner number 1 and petitioner number 5. The prosecution was launched on the basis of an information launched LUNCS, yeah, on the basis of an information, first information lost by one Bosir Uddin Bharbuia, the father of the victim, inter alia alleging that on the instruction of accused number 1, accused number 2 and 5 seized and caught his son and dealt blow to his entire body with lathi, and accused number 4 and 5 caused grievous injury on the head of his son. On the ground that the buffaloes belonging to the informant broke the embankment of the accused petitioners. On the basis of the aforesaid affair, Hailakandi PS case number 181/2004 under section 147, 341/325 IPC was registered. After conclusion of the investigation, the investigating officer submitted search sheet under section
Initially, my lord,
One 47, 341, 325.
search sheet under section 147, 341,
325.
325, 323, 323. On 147, 341, 323 IPC and send them to trial. Full stop. On receipt of the search sheet, summons were issued to the accused person, and accordingly, accused appeared before the learned trial court, and the learned trial court, under its order dated 20/10/2006, took cognizance of offense under thereafter the learned magistrate, under its order dated 20/10/2006, explained the offense under section 145, 341, 323 IPC, which the accused person pleaded not guilty and claimed to be trial. In support to bring home the charges, the prosecution side examined as many as 6 witnesses, including the informant, victim, IO, MO, and 1 eyewitness, projected eyewitness as PW4. Three. The defense sides, however, did not adduce any witness, though their statements under section 313 were recorded. After elaborately appreciating the prosecution evidence, the learned trial court convicted and sentence the petitioners as recorded herein above. Being aggrieved, the petitioner preferred Criminal Appeal 5 of 2008, which was also dismissed by the impugned judgment dated 27/5/2013. 27 to 2013. Yes, yes. Ultimately came to the conclusion that that the learned trial court has not committed any error or illegality in convicting the accused with the aid of Section 34 IPC. Both were convicted with the aid of Section 34 IPC. Yeah. Bottom judicial magistrate order. It was also concluded that the sentence awarded by the learned chief judicial magistrate cannot be said to be harsh or excessive in the given facts of the case. Being aggrieved, the present petition is filed. Being aggrieved, the present petition is filed. PW PW5, PW4, PW4 and PW5 are star witnesses for the prosecution.
PW3, Lordship.
Injured.
Injured is 5.
5 injured, 3. Huh?
Another is 3, Lordship.
3 and 5 are the star witnesses of the prosecution. The from the evidence of the PW, no, Taragote, the learned Mr. Swenso, learned counsel for the petitioner, argues that there are material contradiction in the evidence of the PW5 and PW3, PW1 and PW3, PW3, and the evidence of PW5, that is the injured victim, is not trustworthy. Therefore, without independent corroboration, the accused, the petitioners, could not have been convicted. The learned counsel further contends that medical evidence also did not corroborate the nature of injury as depicted by PW5. Therefore, both the judgments are vitiated by perversity. Referring to, it is further contended by the learned counsel for the petitioner that the PW3, which is projected to be an eyewitness, is an interested witness, and therefore such evidence, testimonies of such witness could not have been placed reliance by the learned courts below. And what was his other argument? What is his other argument? Huh? referring to the
One argument is given, Lordship, written argument is given.
written. To that we have shortcut that the injury is not corroborating. Uh, referring to the evidence of PW, referring to the PW6, the learned counsel further submits that the PW in his deposition, PW6 in his deposition clearly stated that PW6 within bracket IU, stated that on his visit to place of occurrence, he neither found any water in the canal, whereas the PW victim deposed that dispute took place in connection with breaking of the canal made for catching fish. And therefore, on this count also, the testimony of PW1 is not at all trustworthy. According to the learned counsel, all the witnesses, that is PW2, PW3, are interested witness and being the family members of the victim. And therefore, undue reliance has been placed upon this. Therefore, heavy reliance ought not to have been placed upon these witnesses. Per contra, the learned additional public prosecutor submits that the prosecution, through the evidence of victim, has been able to establish not only the attack but also the injury, inasmuch as the medical officer PW5
PW4.
PW4 has duly corroborated the injury. Full stop. The evidence of the PW3, who was an eyewitness, is also has also remained unshaken, inasmuch as only for the reason that he is a relative of the accused, his testimony cannot be discarded at all, inasmuch as during the cross examination, the prosecution, the defense has reaffirmed his presence in the place of occurrence and he witnessing the attack on the victim. Therefore, in view of the concurrent findings of fact, this court may not exercise its revisional jurisdiction to upset such findings, concludes the learned counsel, learned additional public prosecutor. I have given anxious considerations to the arguments advanced by the learned counsel for the parties. That revisional jurisdiction, what is revisional jurisdiction? Then, what is revisional jurisdiction? Since the learned counsel for the petitioner has basically harped on the perversity of the judgment, this court has duly perused the material available on record. From the evidences perused, more particularly from the evidence of the prosecution witnesses, it is seen that PW1, it is seen that PW3, PW5, PW3, and PW4 are the star witnesses for the prosecution. PW5 is the injured victim and PW3 is projected to be an eyewitness. From the evidence recorded before the learned court below, The following facts have been established by the prosecution beyond reasonable doubt. From the evidence of PW 3, it was established that on 10/5, is not it?
Lordship.
Huh?
Lordship.
10/5 or 10/6?
It is not written in the evidence of PW3, Lordship. Took place around, it is stated, one day. Lordship.
10/6/2005. From the evidence of PW1,
10/6, Lordship.
Huh?
10/6.
10/6/2005.
Lord, 10.
From the evidence of PW3, it was established that on 10/5/2006,
10/6, Lordship, 2005.
10/6/2005, on 10/5/2006, 5, the injured, the victim got injured in which part?
Head, Lordship.
Got lateral injuries in his head.
Lordship.
Full stop. Such facts is established through the testimony of
PW4.
PW3 and
It is a medical.
PW5 and PW4.
Lordship.
The injured witnesses evidence within bracket PW 5 regarding the assault upon him by the accused person remain unshaken, and he had described the role of each of the accused in commission of the offense. Such testimony not only remained unshaken, but also was reaffirmed during cross-examination. Injured witness and eyewitness, PW4.
Eyewitness is PW3.
PW3, yeah, PW3. এবারটা যেটুকু হলো, through the injured witnesses evidence as well as through the evidence of the eyewitness PW3 regarding the assault upon the injured remain unshaken, and the injured described the role of each of the accused in commission of the offense. Such testimony was corroborated by the evidence of PW4. Such testimonies not only remain unshaken, but also was reaffirmed during the cross-examination of both the witnesses, that is PW5 and PW3. PW3. The evidence of Dr. From the aforesaid evidence of the aforesaid two witnesses, that is the injured victim and the eyewitness, the place of place of commission of the offense was also identified and established beyond reasonable doubt. Beyond reasonable doubt. Therefore, some discrepancies in the statement of PW6, that is IO, PW6, who allegedly visited the place of occurrence subsequent, cannot be said to be a material discrepancies to exercise this court's power under revisional power to upset concurrent findings of fact when the testimonies of the prime witnesses, that is prime witnesses as recorded here in above, remain firm. Remain firm. It is correct that PW, it is correct that PW3 was a close relative of the victim. However, where is the suggestion that you have given false
Page,
evidence, false evidence?
page 40.
Being the
Evidence of PW3, page 40, Milo, 40.
phase
40, Milo, 40.
40.
Cross part is 41.
কি কলো? Court relative of the, however, taking note of the consistency and nature of evidence of this witness, his evidence cannot be lightly brushed aside only for the reason that he is an interested witness. He is a relative of the victim, inasmuch as the suggestion of the defense in this regard has been denied by this witness. Denied by this witness. The Honorable Apex Court, in the case of State of Madhya Pradesh versus Mansingh, reported in 2003, 10 SCC 414, had held that the evidence of an injured eyewitness has great evidentiary value, and unless compelling reasons exist, their statement are not to be discarded lightly. This court, after closer scrutiny of the testimony of the injured victim, do not find anything to discard his testimony and to disbelieve the same, inasmuch as the nature of injury described by him and by the eyewitness has been corroborated by the evidence of the doctor. In view of the aforesaid, this court finds no illegality or error, not to say any patent illegality in the judgments passed by the learned courts below. Courts below. Both the courts below has duly appreciated the material evidence and relied their conclusion on such evidence and after proper appreciation of such evidence. Full stop. Therefore, this court is not inclined to interfere with the conviction passed by the learned trial court below and affirmed by the appellate court. At this stage, the learned counsel for the petitioner submits that the petitioners had suffered prolonged litigation since 2005, that is for almost 20 years. 20 years. And the nature of injury is also simple, and they have been sentenced to 3 months of imprisonment only. And considering the litigational history, and more particularly the admitted fact that there were some disputes, civil disputes among the two families, in as much as there was no premeditation, but it was a sudden fight due to the dispute as regards breaking of the embankment, this court may reduce the sentence and may reduce the sentence to the period already, reduce the sentence only to the fine. This court has also considered so and so. And considering the matter in entirety, the sentence is modified to the fine already awarded by the judge.
Much obliged.
Which Supreme Court judgment, Mr.
Saying that there the Supreme Court held that the procedure laid down in the juvenile
is to be followed?
is to be followed for determining the age of the accused also.
Victim also.
Victim also. So here, not legal board itself was not considered, Your Lordship. On the age, because firstly there was no school certificate, no certificate from the municipality or panchayat. Doctor gave an age on the basis of an X-ray, which report was given by another doctor, because that medical report shows that doctor was not examined, nor were the X-rays exhibited.
354 will still be there.
Before that is there. Now he has undergone out of 8 years, because he was awarded 5 years, and for 354 he was sentenced to 3 years. Under section 10 he was sentenced to undergo 5 years 6 months. Out of that period he has underwent 7 years 3 months 17 days.
I think already he has been released, because it should be concurrent.
That
No,
word is
that-
not there, Your Lordship, in the judgment. That means it will be.
Hard. Hard, Mr. Pathak, learned amicus curiae. Mr. Swenso, who will appear for you? Okay. And so Mr. Saikia for the informant, a victim or informant. Informant. The present appeal is directed against. Okay, 2. We'll dictate this order. How many matters are left, please? Please call the matters who are here. No, we will not continue, but please call who are ready, who are not ready. Accordingly, we'll make a plan.
5, my lord.
Item 5, are you ready? You want to do it? Huh? Okay. 3 also ready. 5 and 3 ready. Okay. Then. Okay, after vacation.
Your Lordship, item number 3 and 5 has been undergone by PP Borthakur. So he has gone for emergency, Lordship.
Okay, then we'll have to give some other date, huh? Item number 3 and 5. It is submitted that Mr. Borthakur, learned additional public prosecutor, due to some sudden problem, had to leave the court, and therefore an adjournment on his behalf is made. Class tense allowed when? Not before vacation. Date, give a date. Also. That's why I'm asking. Unnecessarily, will you wait and again adjournment? Whatever who is ready will do that. No pressure before vacation. 8th of January. Yes, any other matter? She is not well.
Here, she will do
Item?
19, item number 19.
Okay, okay. Is she ready?
Very much.
Okay,
We got the
okay. Ms. R. Chaudhuri, learned amicus curiae, submits that she has been furnished with the document yesterday only. Okay, if she will do, no problem on that. Yes. Yes, and which are the other methods? 21. Okay, so how many methods are left to? 3 more methods. We'll continue dictation your method, then we'll go to the other methods. That much.
Delegation.
Where is the?
Your lordship will find at page number 4, your lordship.
Now it is conviction under
354 and section 10 of the POCSO.
10. What is 10?
Aggravated sexual assault.
How can aggravated?
Because I have gone through the ingredients. I think because they have taken the age of the victim as below 12, then it falls under aggravated.
M. Bizni in CR case CR number 312 of 2010. That judgment is also under challenge.
Both the judgments are under challenge.
The further challenge is the judgment and order dated 7/6/2011 passed by the learned SDGM within bracket M. Bizni in CR number 312 2010. Full stop. When the matter was listed for motion on 25/6/2012, this court recorded that the learned counsel for the petitioner submitted that except monetary relief of rupees 30,000 as awarded by the trial court and affirmed by appellate court, rest of the order are not in challenge in this challenge in this petition. Accordingly, considering the said fact, the monetary relief granted 30,000 by the trial court and granted was stayed by this court. The brief facts leading to the present case is that
If lordship come to the page 28, this is trial court order.
Page
28, trial court order, lordship. Details judgment has been given.
the respondent wife filed an application under section 12 of Protection of Women from Domestic Violence Act, hereinafter referred to as the DV Act, so you have to do, Act, internally alleging that the petitioner husband had deserted her and got married to another woman. And was merrymaking with his newly wedded wife, ignoring the basic requirement of the complainant. It was also stated in the complaint that they have a daughter who is pursuing studies in class 8 at that relevant point of time. Accordingly, prayer was made seeking protection under section 18, residence order under section 19, maintenance order under section 20, and compensation under section 2020 of the Act. The petitioner husband filed a written statement with contentions that the respondent the contention that the petition is not maintainable and denied that he had committed any kind of domestic violence in a form of mental/physical, verbal or emotional abuse. It was also contended that he made no economic violence as well as dowry related violence against his wife.
Discussion is at page, para 14, Lordship, page
Yes.
31, Lordship.
After elaborately, any evidence laid?
Yes, evidence has been laid.
How many evidence witnesses?
PW1, Lordship, PW2, PW3, 3 witnesses.
The complainant husband the complainant wife in support of her case has laid as many as examined
3 witnesses.
3 witnesses including herself. The husband, any witnesses?
No, Lordship.
The husband, are you sure?
Lordship, only his, Lordship, here is stated in para 13, Lordship. On the other hand, the respondent also adduced his evidence stating that at no point of time, that means his, only he has given that.
The respondent husband examined himself as DW1 in support of his case. After elaborately discussing the evidence, more particularly discussing the testimonies of the witnesses, the learned trial court concluded that the respondent concluded that the respondent husband in his written statement as well as in his evidence candidly admitted that he married another wife and now he has been residing with the second wife in another place. Accordingly, it was also concluded that the respondent husband has failed to offer any possible explanation as to what prompted him to leave the company of the aggrieved person with whom he spent 18 years of conjugal life. And it was from the evidence, it was clear that she has been able to establish her inability to no. The learned trial court also concluded that the husband has refused to maintain the wife and
Para 14, if
considering the admitted position that the salary of the respondent was 17,000 per month
No, Lordship, it was
No,
the
sorry.
trial code. Yes. Trial code concluded that the salary is 20,000 more than 20.
With the learned trial court also concluded that the salary of the respondent was more than 20,000 per month,
So it's Lordship, not less than 20.
not less than no, it is, yes, it's drawing not less than
Not less than
20,000 salary per month. It was also concluded that the act of the respondent husband prima facie constitutes domestic violence upon the petitioner, upon the complainant. It was further observed that the absent husband cannot be allowed to treat his wife and children as an object and behave in a manner he likes. It was also concluded that the respondent has failed to disprove the allegations by adducing his defense evidence, inasmuch as the wife has been able to establish her case. Accordingly, the impugned order was passed by directing to pay maintenance of rupees 3,000 each to the complainant and her daughter per month.
50,000.
And such amount is to be paid within second week of every English calendar month, so that they can live a modest life.
Addition to that, 50,000 also been one.
Where is that 50,000?
Lordship, page 33, Lordship.
30. I'm reading at 33.
Lordship, monetary
In
relief.
addition, what's it? Where is that?
Monetary relief under section 21A 1D, Lordship, as
Okay. The learned trial court also granted an amount of rupees 50,000 under section 20 within bracket 1 within bracket D of the DV Act. Is that it?
Yes, Lordship.
So, being aggrieved, the petitioner approached the learned appellate court, which was registered as criminal appeal number 17 within bracket 3/2011. The learned appellate court, after reappreciation of evidence, while upholding the judge,
It was partly allowed.
uh,
Lordship, 50,000 has been reduced to
upholding the judgment so far relating to award of maintenance, modified the award of compensation under section 20
1D.
within bracket 1 within bracket D to rupees 30,000. And being aggrieved, the present application is filed. Revision. What is the ground of revision?
If Lordship, I draw your Lordship attention.
Dismissed.
If Lordship, I draw your attention, Lordship, they have stated that without their consent in the revision, they have stated that without their consent, adoption has been taken. But in the trial court, they have stated.
Will not go to the adoption. These are not the ground.
Yes.
Dismiss. Dismiss and dismiss registry to send a copy of this order to the learned. Which was this court? Trial court?
Trial court is the
To
SDGM
learned
Bijni.
trial court.
SDGM Bijni.
SDGM Bijni.
And the release of the order, Lordship, the 30,000 has to be paid, Lordship.
That is what I'm saying. You file an application there. LCR be returned back. We'll modify, we'll get it in the month of January only, order, final order. Yes, madam. Item number? What is this?
Conviction 1.
What do, according to you, what are the what if any bodily injury, something like that? So if there is no injury, after vacation. Nobody's there. How many orders amicus are being entrusted? We'll take action next year against the lawyers. No way out. See the last case, we'll have to see everything, read everything. And in the process, we may commit mistake also. Why should we burden amicus, then ask them to pay from the state exchequer? Let the lawyer, let the lawyer who is not appearing pay compensation. Pass orders. Yeah. Some other day,
In the month of January.
January. If you want to reverse it, you need to have a detail. Otherwise, if you affirm it, not so much is required, revisional jurisdiction. But to reverse it, we'll have to discuss why it is we are reversing it. Ultimately, two courts concurrently formed. All give dates. Enough for today. He has been served with the record yesterday, particulars on yesterday only. Accordingly, matter be listed on date na January for hearing, for final disposition.
Apply.
What is this?
Under 498A.
All matter for dismissal or allowing? If it is dismissal, we'll dismiss it. 3 pages dismissal,
Good merits in this case.
good marriage, then after January. Evident. If we have to discuss, go through the evidence, then
My
January.
lord,
Contradictory and
That's why you will have to deal with it.
my lord.
You'll have to give a chance to PP. PP will have to object that this is not contradiction, this is not it. If we are in PP's favor, dismiss it, then no issue.
the
498A.
husband has a relation with other girl. This is the main.
Whether it will be whether it will be cruelty. What kind of cruelty is required under 498A? Tell us.
There should be demand of dowry.
Let us see 498A, what it says.
Sexual assault.
Read it.
The husband or the relative of the husband of a woman subject such woman to cruelty and shall also be liable to be fined.
Cruelty means
Cruelty means any willful conduct which is such a nature as is likely
or cause
to
grave
deprive
injury or danger to life, limb, or health.
of number due to curse her or any other to meet any unlawful
Or dowry only dowry demand will also do. After vacation.